in from, good morning as well. My case does not present quite as complicated a set of facts as the one that was prepared just now. However, it does raise an interesting point, at least one interesting point, which I will touch on as I go through my slides. I think one thing before I start this case that I should say is that I completely agree with everything that has been said so far in terms about being very careful on the facts, being very mindful of what you say, and in particular, if you're going to sign something, know why you're signing it. Because it could come up to one of two things. You could find yourself being bound to a document that you may not have thought was a contract, or in the other way, you might end up with a document not being binding, even though you thought it was binding. Now, the case that I'm about to talk about is one where the parties argued whether the document was binding or not, whether it was a valid contract or not. But interestingly enough, at the end of it, the court's decision was even if there was a contract, it had been terminated. But even though it had been terminated, the broker in this case may still have been entitled to commission if he could prove that he was the effective cause of the contracts ultimately. Now, that is an interesting point indeed. So I'll get to it. The facts are nowhere near as complicated as the multi-jurisdictional disputes that we were just listening to. But before I do, I must ask for your understanding. As Punit has very kindly highlighted and forewarned, I was personally involved in this case, in arguing this case. So you must forgive me if I therefore have a little bit of a biased perspective to some of those facts. And I disclose that upfront so that anything which you look at and you go, but why would he be so favorable to one side? That was my client. And I will continue to be favorable to that side. And for in the interest of full disclosure, that's PCL shipping in this case. Now, here are the background facts. And as I said, not particularly complicated. All of this took place in 2013. The Ceylon Shipping Corporation, CSCL, a state-owned company, issued a public tender at the end of 2013 for expressions of interest for a coal shipment, a coal transportation contract, and a fairly lucrative one as well. Now, the deadline was stated there to be the 31st of December 2013. During the case, there was some argument on whether or not PCL did or did not submit it before the 31st of December. There was some argument on whether or not the other side, SAR Maritime, had managed to procure an extension of time for PCL to submit. Either way, eventually it was submitted by PCL, and PCL was in January 2014 invited by CSCL to submit a firm offer for the contract. That firm offer, as we will see later, was subsequently opened with a whole bunch of other offers in a public, well, in an open setting with all of the offerers together at the same table. So after the end of February 2014, PCL continued discussions with CSCL. Now, at the bottom of this slide, you see a reference to SAR. SAR, during this time, was conducting lobbying for PCL. That was the assistance, the services that SAR was saying that it was doing during this time. As we will see later on, there was no contract in place at this point of time. The question of the agreement came about subsequently, but during this period, December, January, February, SAR was, shall we say, in the picture. And I'll try to be as neutral as I can be when I use that terminology. So let's go to the crucial dates. As I said, during those periods of time, there was no contract. Now, in May 2014, PCL and SAR signed a one-page document, and it was titled Brokerage Agreement. And it's important for me to highlight that it was titled Brokerage Agreement because some would look at that and conclude, oh, that's a contract. It says agreement. Both two commercial parties signed it. As a matter of Singapore law, at least, there is a presumption in commercial transactions that when you enter into an agreement, you have an intention to create legal relations. But I should point out that this was something which the trial court and the Court of Appeal disagreed with. The trial court held that this was not a binding contract. The Court of Appeal held that it was a binding contract. And they looked not only at the terms of the contract, they also looked at the subsequent conduct of both parties to see whether or not it shed light on whether they did or did not intend to create legal relations. Now, I've not just set out the important terms of this one-page document on this slide. I have pretty much set out the entire document on this slide. That's all that it really says. There were a couple more sentences, but these are the only ones which were really there. Now, I'll leave this aside for the time being. You can see for yourself what it says. You can make your own judgment call as you look at the screen, whether you think that is sufficient to amount to a contract or not. But what I wanted to point out is that if you look at it, 8th of May, they signed the document. 21st of May, PCL writes to SAR and tells SAR, your services in lobbying and representing PCL are no longer required for this with immediate effect. So that then becomes an issue of termination. Now, that doesn't mean that there's no contract, no matter how short it may or may not have lived for. And that's the first point I wanted to emphasize. What did the court hold? And in this regard, I'm talking about the Court of Appeal, whose judgment came out earlier this year and therefore falls within what Punit said was at least this year's recent cases. The High Court decision was last year. The Court of Appeal disagreed with the High Court and said that, no, hang on, regardless of how short it was, how brief it was, and for how short it was in existence for, that was a legally binding agreement. It was an identifiable agreement. The contents and the terms were complete and certain. The quantum of the commission, the conditions subsequent to be satisfied, the conditions for obtaining the commission, the Court of Appeal felt those were all there. And therefore, there was evidence that the court held that the parties did intend to create legal relations. Now, on that point, you've seen kind of my summary of how the court came to the first two points above. But on the third point, the court did ask somewhat rhetorically, well, why would you sign this document if there was no intention to create legal relations? And I pause here to say that's a question that both sides will always have to answer in any case such as this, where the existence of a contract is in question. Because if one side is saying there is no contract, then you must have a plausible reason why the contract or the document was signed. Again, bearing in mind that in a commercial, not in a social or a familial context, but in a commercial context, in a business context, at least under Singapore law, there is a presumption of the intention to create legal relations when you enter into documents like this. So on this basis, the court held, yep, there was a concluded and a binding contract. However, the court said the contract had been terminated on the 21st of May, and I've already brought you through the email that was sent terminating the contract. Now, what happened, which is what I wanted to emphasize, is that SAR's reaction then became crucial. It became a focal point of both the trial and the appeal. What did SAR do in response? And in this regard, what SAR did on the facts was that it emailed back to say it would suspend its lobbying, but asked that it would be reimbursed for expenses already incurred for lobbying efforts. SAR then also said it would remain and hoped to continue to remain in the capacity of a handling and husbanding agent for PCL, which it was during this entire period as well. Now, during the trial, SAR agreed that a commission broker would not be the same as a handling broker. And that's a point which the Court of Appeal also noted. So taking the conduct, the second point that I mentioned earlier, the conduct as a whole into account, the conduct of SAR led the court to conclude that no, you knew it had been terminated. You in fact acknowledged the termination of your services as a broker, but you wanted to make sure that you continued in a different capacity, namely as the handling agent. So on the facts, the court held it had been terminated. This is important because SAR ran the argument that it never said that it would be terminated. SAR said it would simply suspend its lobbying and said that's not the same as accepting a termination, and it didn't conduct itself as if it was termination. So I won't go into all of the detailed facts in more detail right now, save to say that the court looked at the whole set of facts and concluded, no, it clearly was terminated. Again, before I reach the next few slides, that was not the end of the question here. It would have been possible in a different case for the court to say, having terminated the contract, your entitlement to commission ends because it could only arise out of contract. But the court did not say so in this case. And how to, as it were, manage that set of circumstances, the court gave a little bit of guidance, but one that will ultimately need to be filtered through the specific facts of any relationship or any case. I'll just finish off what happened after this. So after the termination, PCL appointed a different broker, one Mr. Satak, and he then took over the negotiations with CSCL. Following that, things took what the court described as a different course, and indeed, PCL got the contract with CSCL, not just one contract, several further amendments to the contract and addendums, such that there were, in truth, multiple contracts of affreightment that were entered into and secured by PCL. So what SAR did was it sued. It sued for 1% of the freight for all of the contracts of affreightment, which was signed after it had been terminated. Now, this is the crucial language that I wanted to speak about, which I think is the point which Punit identified as to why he wanted to speak about this case today. This is a quote from the judgment itself, and it says that in the absence of clear and express language, in other words, in the contract, to the effect that the agent's right to commission will only crystallize if it saw the transaction to the end. That's a guidance on contractual language, In the absence of that, it is implied that an agent would, and I'm inserting the word here, still or could still be entitled to commission if his services were the effective cause of the transaction. And I should explain that that's taken from a context different from maritime law, at least in this case. In this case, that principle was taken from a real estate agent case. But the principle that the Court of Appeal ultimately applied to this case is as stated on this slide. So let me explain what then happened, right? The court ultimately held that SAR was not the effective cause of the CSCL contracts. And in this regard, this is really on the facts. I would not take this as being determinative of any other case in the future. What I'm describing in slide number 8 is the facts of this case. In fact, the court took great pains to explain and emphasize that it will ultimately always be a factual analysis. Now, SAR argued, based on some academic commentary in maritime textbooks, that the introducing broker is always the effective cause of the contract. That because your role as a broker is to introduce, you must be the effective cause. And the Court of Appeal rejected that argument as being automatic, if you understand what I mean. So what the Court of Appeal explained was that in an ordinary chartering case, and in this regard, I'm quoting almost from the judgment, the introduction by the broker is crucial. That is true, because otherwise the owner doesn't know the identity, the needs, the requirements of the charterer without the introduction of such a broker. So in a single charter party case, the Court of Appeal felt entirely possible that the introducing broker, by the fact of introduction, may very well be the effective cause. However, in this case, it was different because the CSCL contracts were awarded and advertised by way of a public tender. So the introduction, as it were, became less crucial in these circumstances. Furthermore, it also involved a long-term transportation agreement, which went through several changes. That was a separate, much more detailed fight on expert evidence in the trial, which I don't need to go into here. But those agreements changed as time went on. And the evidence before the court was that a broker in a situation like that to be the effective cause not only of the start of the commercial relationship, but seeing it through all of those would still have a role to play in negotiating those terms, in bringing the parties together. And if the broker pays no part whatsoever in those subsequent addendums, as I said, those subsequent negotiations, then there's no assumption that the broker becomes entitled to the commission for those contracts merely by the fact of the original introduction. So on the facts of this case, that's where it really happened. So there was a second limb to this, and SAR argued, but hang on, it's not just that I introduced the CSCL to PCL. I also provided, I'm trying to remember the exact words, I believe it was invaluable information, right, on what CSEL's requirements were, right? And I also made it possible for PCL to submit its expression of interest out of time. So as I said, these are factors which may not appear in any other case, but the specific facts will be crucial, because on this case, it was not possible to establish clearly that that was in fact the case, that in fact it was SAR that allowed PCL to submit its expression of interest out of time. SAR also said, look, I did lobbying efforts, I put you in a good position to ultimately get the contract. And my reading of the court's judgment is that if that was true, then the possibility of effective cause would still be there. But on the facts of this case, the Court of Appeal held, no, that can't be correct, because the information that you provided was already contained in the tender documentation. The information you provided didn't result on the facts, with PCL having a superior bid or a more competitive bid, and it still had to scrap with the rest of the 8 bidders to get the contract. And more importantly, your lobbying efforts were specifically prohibited by PCL. PCL told you they didn't want political interference in this case, and you continue to lobby to try to get political interference and political intervention in the case. And in fact, that was the reason why your agreement was terminated, and that was contained in the judgment. So once again, interesting facts, but may not be present in every case. But that's really the crux and the point that I'm trying to make with the presentation. These are the principles that I glean and I extract from the Court of Appeal's decision here. The broker must effectively broker the deal. It must be the effective cause if it is going to say that in the absence of an agreement, it should be entitled to commission, perhaps on a market rate basis. But you could oust that if you drafted a contract clearly enough between the broker and the ship owner. You could do so, but that's not what was the case here. The court then went into pains to say it is not trying to provide an exhaustive or precise definition of effective cause. It also took pains to say no one factor is determinative, because otherwise the whole introduction argument comes back into the play. The idea that because you could not have gotten a contract with somebody who you didn't know, therefore the person who introduced you to the counterparty is necessarily the effective cause. The Court of Appeal has rejected that as an assumption. It's a holistic assessment of all of the facts, but it's not enough. And nobody is saying that the agent plays. Nobody is even saying that the agent doesn't play an important part. But unless it can be shown on the effective cause analysis outside of the contract, in other words, unless it can be shown that the agent was the critical cause for the closure of the contract on the terms on which it was closed, the court may not find that the agent, the broker in this case, was the effective cause. And so that was a very interesting point to argue in the Singapore court, and I'm grateful to SCMA for giving me the opportunity to speak about it with all of you.
Thank you so much, Jason. This was, as I said, a very interesting case, something that I have not come across in so many years of my commercial shipping career as well. But if I can just share a little bit on the commercial side, just reiterating what we have been trying to, again, emphasize. I'll just quickly recap some of the aspects that we've gone through. The first thing, of course, is when is a commission earned by a broker and agent? That's the kind of key aspect to look at here on the commercial side. What constitutes a binding agreement? You've been through these 3 aspects: the identifiable agreement, complete and certain, a consideration and intention to create legal relations. And then, of course, the termination also has to be a clear one, a clear notice. Acceptance is through conduct, and the mutual agreement implied that we want to terminate the agreement. This particular case was very unusual in the sense that you had actually a separate brokerage agreement agreed, just a one-pager. And then once the charter party was done, a final agreement would be incorporated in the charter party. And that's something which doesn't happen very common. Usually it is in the charter party or it's not there. So this was a very different feature for that particular case. And for the effective cause discussion, I think you've already been through most of these cases, but the real fascinating thing for me was that there is actually something like this written in Carver's Carriage of Goods by Sea, and that's quite interesting to see that there is a precedent about this. But of course, the introduction of brokers to the parties and the uniqueness or the ability to do that singularly is usually a domain of exclusive ship brokers today. There's no other reason why parties would not know about the identity and the needs of the other parties, with the technology being so open today. But the fact that each case is different must be kept in mind. But just the fact that you can even be entitled to commission even after the contract is terminated is actually quite different from what we all perceive or believe. So I'll just quickly do the lessons learned. A binding agreement requires these three elements. That's something to really take away. Agreement can be terminated by clear notice in conduct, or might be terminated, as you said. If the agent or the broker is the effective cause, he may still be entitled to the commission even if the agreement is terminated. And usually, if you want to avoid ambiguity, it's advisable to draft a clause or an agreement clarifying how and when the contract can be terminated, and also when the commission is earned under the contract. Now, it's difficult to do that, and I don't think we can prescribe model clauses, but it's definitely one of the points to take away, that there can be challenges of a very different kind than what you envisage today. There are standard contracts. The FUNASBA brokerage agreement is actually having a clear arbitration agreement. So if there was an arbitration agreement between the parties at some point of time, it could have also helped keep this whole thing P&C, for example. In this case, of course, it has now become public. So there are lots and lots of things. The cost structure could be very different depending on the fact that you don't have to go to the courts. Also, the fact still remains that you have this. Jeffrey just pointed out in one of the questions saying there is actually a shipbrokers P&I club, the ITIC, which obviously can also help in a case like this. So these are the kind of main lessons learned. Difficult to prescribe a model clause which should actually take care of a situation like this. But when you share these perspectives, your antenna goes up as a commercial guy. You really start thinking that something like this is possible. So I need to really make sure that I do what I have to do to ensure that this doesn't go into a tailspin again. Captain Dutt, would you like to add something from your side? I mean, your experience has been amazing in terms of dealing with brokers, and a lot of our members are brokers. So this is quite relevant to them, yeah?
Thanks, Punit. I think you have again summed it up very well, leaving very little else that I could comment. But yes, the FUNASBA agreement, yeah, that's a good template to go by. Again, many people may not know, but and FUNASBA is a sister organization to the ICS, to the Institute of Chartered Shipbrokers. And yes, it has the arbitration clause as well, which probably in hindsight would have made it very much cheaper for SAR versus paying legal expenses. So that is one. There are, yes, because at that stage when SAR entered in the agreement, for want of a better word, I would describe it as fragile, because it would only be replaced by a solid agreement when the actual contract was awarded. Yeah, after that it would obviously be rock solid in nature. So I don't know what SAR could have done. Probably put a NC non-circumvent sentence in his agreement to sort of reinforce his position until it was replaced by a contract. That's it. Of course, our comments are coming in hindsight, really. And you're right to say that rarely do you have a brokerage agreement. It is just included in the main body of the charter party. But I understand it's not enforceable there in a charter party as such. So yeah, a few lessons learned for our broker team. I think Jeffrey's comment on ITIC is very relevant. But if SAR was a member of ITIC, then it would apply. It looks like he wasn't. Yeah. But thanks again. That's about the comments I have.